Of State of Juristan versus Armahan Randawa.
Good afternoon, your honorable judges. Before I start my arguments on the facts of the case, I would like to the instant case of the state versus Armahan and Dawa. I will be giving sure, Your Honor. Mutter, Ms. Myra Sobat will be giving arguments on the remaining 3 questions, and along with us is Ms. Isma Riaz. She will be giving authorities to the honorable judges. Aware of the facts of the case. Sure. Jurisdiction to try the case. As per the facts and according to the economic zone of the state of jurisdiction, whereas as per the facts of the case, the incident took place within the territory. And in order to fierce my arguments, I would like to mention territorial principle of international law, which says that whenever an offense is committed within the territory of accused, the same state has the right to adjudicate the matter. And in order to fierce my arguments, I would like, Your Honor, I would like to refer to the case Campania Naviera Vescangado versus Cristina SS 1938. Here in this case, the relevant thing is that the ship Cristina was of the private company, but it was used for the purpose of trading by Spanish government. Hence, it was considered under the jurisdiction of Spanish government, and it attracted territorial principle. The same can be applied in our instant case. Hence, the state of Juristan has the jurisdiction.
Would you repeat the very facts of this case?
Sir, to be very brief, or should I repeat it with the case law?
Only
Para 2 of the case.
would you assist the court regarding para 2?
Your Honor, I would like to assist the court regarding the whole judgment. Your Honor, there was a ship. It was owned by the private company, and the private company was of a neighboring state, and it was used by the Spanish government for the trading purposes. That as it was under the contract of Spanish government, so it was under the jurisdiction of Spanish government. Hence, it attracted the territorial principle. The state of Juristan has the jurisdiction of Islamic law. This is a legal principle. Whenever any offense is committed, regardless of the relation to the prosecuting, Your Honor, territorial jurisdiction, it says that the provision of this could apply also to any offense committed any person in the service of Juristan in any place without and beyond Juristan. Any person on any ship or aircraft registered in Juristan wherever.
Juristan, yes?
Yes, Your Honor.
But you did not give any authentic or relevant international laws reference.
Your Honor, in the instant case, the section 4, although it applies, but no such similar incident ever happened in the history of Juristan, so we were unable to find any
reference of international law.
Your Honor,
Any authentic article
related to section 4?
related to jurisdiction.
Okay, I mentioned the case law, but regarding universal principle, there was no case law available. But however, it is important to mention here that there is a saying of Juris Star. Your Honor, Juris Star.
Not saying, not judgment, but articles in any law, whether be it law of sea convention or anything related to that.
No, Your Honor, nothing is available. However, there is a statement of Juris Star. He was from 1960 till 1969. He said whenever an offense is against human right, it is considered as We all know that murder is against human right, hence it attracts delict jus gentium and automatically attracting universal principle.
Counsel, as we know that the ship is going somewhere in the sea. Kindly clear it.
Okay, Your Honor. As it is clear from the facts of the case that when the shark hit the ship, it completely destroyed the communication and navigation system. So it was impossible for us to find the exact location. But as they were recovered by Zawada Coastal Guard.
Means the prosecution is not clear about the distance and the place.
Yes, indeed, Your Honor, because of lack of navigation system. Okay. Section 4. Yes, Your Honor.
My point is that whenever there is a conflict of laws in terms of the domestic laws as well as the international law, so there is a concept known as highest caucus, which means that in most circumstances the international law is going to prevail. So please brief us that why in this circumstance international law is not prevailing and you are confined to your point that section 4 of JPC is going to be implemented.
Sure, Your Honor. As I mentioned, that the definition of Section 4 is any person in the service of Juristan. And as we all know, Mr. Armaghan Andawa and Dilruzain Qazalbash were under the service of state of Juristan.
But still, the question remains that why the international law does not.
Previously mentioned two principles are of international law. Hence, I hope that within the territory of Juristan.
Navigation बता सकते
Sir, as I mentioned earlier, the navigation and communication system was completely destroyed. So it was. Yes.
और यहाँ पर क्या इम्पेरेंस ड्रा करें जब नेविगेशन सिस्टम नहीं है तो आप कैसे इम्पेरेंस ड्रा कर रहे हैं कि जो टेरिटोरियल वाटर में
Indeed, Your Honor, because as per the facts of the case, they were rescued by the Zawada Coastal Guard, and they are the official executive authority of the state of Juristan, and they cannot cross territorial limits of the state.
And what about the 250 nautical miles?
Yes, indeed, Your Honor. It was an inference.
It was inference.
Yes, Your Honor. Clear?
Okay, what happened? What is the name of offense committed in the territory of the Juristan you're claiming? What is the name of offense? What happened?
Sir, it was indeed Qatl Amr under section 300 of Juristan Penal Code. And my second question is regarding the same, Your Honor.
No. Under section 302, would you like to read it out? Section 302 of Juristan Penal Code.
Sir, section 302 is related to punishment. However, the definition is given in section 300.
Okay, 300, yes.
Yes, Your Honor. Should I read or should I
Yes,
just
read it out,
Okay.
please.
Your Honor, it says, whenever with the intention of causing death or with the intention of causing bodily injury to a person by doing an act which in the ordinary course of nature is likely to cause death, or with the knowledge.
Where is intention in this instant case?
Your Honor, as per the facts of the case, if I refer to para 9, line 5 of the facts, it is clear that Armaghan Andawa is reciting prayers, whereas Firoza Bill is holding the legs. Meanwhile, Armaghan Andawa used his pen knife to cut the jugular vein.
Here in section 300, the word intention is used in negative sense, mean guilty intention. Survival. If survival is a positive thing, positive intention, so how are you going to negate it?
Okay, he was in coma. He tried to do the same, and for that I would like to refer Honorable Court to the para 7, line 2 of the facts, which says Armaghan Andawa approached Dilruzain Qazalbash with the intent to kill him. It clearly indicates that they had felonious intention. Sir, utilitarianism said whenever any act is done for the majority of people's benefit, so it is justified.
So don't you think it is justifiable on that of trying?
Of course, Your Honor, but when there's a law, when there's a precedent, I'm referring to section 300 of Juristan Penal Code.
300 is about Qatl Am.
Yes,
but
indeed.
cannibalism is something else.
Yes, indeed.
So
Your
how
Honor.
you will justify this? The thing
Cannibalism?
which is neither clearly mentioned in your criminal statute, how you are going to prosecute in
Case, the cannibalism is also murder. Case, it is murder because cutting of jugular vein
the fact this is the case. Now you have drafted. You are a prosecution.
Yes,
so
Your
you
Honor.
have drafted.
Yes.
So definitely you have drafted in your own favor.
No, Your Honor. It was not drafted in our favor. It is the fact. And one more thing.
You collected the fact.
One more thing I would like to say.
You collected the fact.
Your Honor, if I refer you to the facts of the case, the last paragraph says, when they were rescued by Zawada Coastal Guard, they confessed voluntarily.
Wait. Where it is?
The word is mentioned, they truthfully shared the details, and in those details they confessed that Armaghan Randawa cut the jugular vein, which is indeed a confession.
I'm unable to comprehend your answer, my dear.
Okay, Your Honor. The last paragraph or the last para of my instant case, Your Honor, please refer to the last page of the facts. It says the first line, where they truthfully shared the details. Now, the share the details, which indeed is a confession.
The status of this confession.
Your Honor,
Whether it is admissible,
indeed, Your Honor, it is admissible.
it is before the authorities, not before the court.
I would like you to refer to, I would like to mention Article 41 and 37 of Qanun-e-Shahadat. If we remove three important things. Number one, there must be no threat. Number two, there must be no inducement. And number three, there must be no promise. And as per the facts of the case, all these three things are missing. Hence, according to these two articles, the confession is relevant. Moreover,
What is the presumption regarding the confession taken during
confession is relevant and relevant after corroboration with the facts and evidences.
how it is corroborated?
Your Honor, Zawada
Come in the definition of that law enforcement agency, mean police.
yes.
So it is not admissible under Qanun-e-Shahadat.
Okay, Your Honor. It is also said that it is if the confession is truthful, voluntary, then after corroboration it can become relevant. May I proceed to question number 2, Your Honor? The question number 2 is whether killing of Dilrozain Qazalbash was considered murder under the circumstances of the case or not. Indeed, Your Honor, under Section 300 of Juristan Penal Code, it was murder because Section 300 of Juristan Penal Code says that intention and knowledge of act that caused grievous hurt and led to the death. As I have already referred the Honorable Courts, I would like to mention a landmark judgment, that is JLD. Please refer to para A. Your Honor, it says felonious intention and causing injury resulting in death. Felonious intention of accused held proof. Your Honor,
Gentlemen, how would you define felonious intentions?
indeed,
And how they differ from the intentions of Armaghan Randawa?
Armaghan Randawa had the felonious intention. As per the facts of the case, Armaghan Randawa used his pen knife to cut the jugular vein. But before that, Armaghan Randawa signaled to Firoza Bill as well, which clearly indicates the felonious intention of both. Your Honor, the last thing I would like to mention is confession, which I have already cleared before this Honorable Court. If the Honorable Judges don't have any question, I would like to call my co-mooter, Ms. Myra Sober, to argue on the remaining 3 questions. May I, Your Honor?
Oh, wait.
Yes, Your Honor.
Here, under Section 4 of GPC, you are claiming, or under Section 3 of Juristan Penal Code.
4, yes, Your Honor.
4. So, would you like to read it out?
Yes, Your Honor. It says the provision of this code apply also to any offense.
One year, but the fact here it says that a contract has been expired, and the wording is crystal clear. There is no ambiguity in it. It will be automatically expired.
Yes, Your Honor. Indeed, the word automatically expired is mentioned, but the word that when the contract started is not mentioned. So we don't know the exact duration of the contract, because as per the facts of the case, it is just written that they started their journey on 1st June 2022, which does not mean the contract also started on 1st June 2022.
If you calculate the dates, right? Almost.
To find the exact duration of contract, it is very important to first know the starting point of a contract. And as per the facts of the case, when did the contract start? It
When
is
they have
not
started the journey.
on 1st June.
So from that very date, calculate the dates.
However, yeah, Your Honor, it is not proved that the contract also started on 1st June.
When you are going to start a journey or when you are going to work on any project, what does it mean? Contract has been signed.
Yes, Your Honor. The contract was for the purpose of finding natural resources. The contract would start when they start finding the natural resources, and the duration, the time duration till which they start their journey to reach that point is not included in the contract.
So what is the need of that, technocrat to go before their term of contract? What is the need of?
Pardon me, Your Honor.
You stated that it is not clearly mentioned in the fact, right? So what is the need of those technocrats? They went to the high sea for the very purpose. Before starting of the contract, कोई क्यों जाएगा समंदर में?
Because resources can be found in the place from where they have to find resources is in the sea. That is the place from where they have to find the resources is in the sea. That is the reason they went in the sea.
So it's mean in the matter of a common sense, contract has been signed before. That's why they have started their journey.
The contract was for the purpose of finding resources. So when they will reach that point and they will start exploring the resources, their contract will start from that point. Okay, I would like to. Yes, Your Honor.
आप इस कोर्स से क्या चाहते हैं?
Tutorial principle,
स्टेट का नाम सिर्फ मेंशन
sir, state of Juristan.
फॉर द सेक ऑफ गवर्नमेंट इसको नया ही ट्राई करें, ठीक है? इसको यूरिशिया कर दे, सही है, लेकिन एंड में तो कल्प्रिट को टू ब्रिंग हिम बिफोर द कोर्ट एंड टू ब्रिंग हिम इन द बुक, सही है? सो व्हाट इज रॉन्ग विद इट? कोई भी स्टेट अगर इसको कल्प्रिट डिक्लेयर कर ले, कहीं पर भी ट्रायल चल जाए, तो इसमें व्हाट इज रॉन्ग विद इट?
Okay, Your Honor. The first thing we have to understand is that they were in the territory of Juristan. Second thing, they were in the service of Juristan. Third thing, two nationals of Juristan were also is competent.
आपने यहाँ पे बोला कि दो नेशनल जुरिस्तान के थे, क्या ये फैक्ट में मेंशन है?
Yes, indeed, Your Honor. Your Honor, please refer to para 8, para 3 of the facts of the case. It says Juristan hired two experts, Mr. Armagan Andawa and the Ruzain Kazalbash, and they were the nationals, and they were the nationals of the other state, Your Honor. However, these facts are silent about. Facts are silent. Facts are silent, Your Honor, and any prudent mind can infer that they are the nationals of Juristan. If it is logical, Your Honor, we can infer at least. Now I would like to call my co-moocher.
Wait. It is not a civil law. It is a criminal law. What is the standard of evidence for a criminal law?
In what sense, Your Honor?
This is a criminal matter, right?
Yes.
What is the standard of proof in criminal matter?
Sir, it is clearly defined in Kanuni Shahadat or
It's beyond any doubt.
Mere of assumption or proposition or probability, can a penalty be imposed?
no, Your Honor. I am not saying that the penalty should be imposed.
Your case is totally based on assumption. There is no material fact in it. There is no material evidence in it. So you are demanding that the 3 person will be, will be given a death punishment. Don't you think it will be unjust, unfair?
No assumption, but of Juristan in a court.
The standard for criminal matter is that to prove the case beyond any reasonable doubt. But your case is, full of doubt.
Okay. Your Honor, according to I would say, as per the confession that was made, it is proved that Armagan Andawa is liable.
That confession is neither made. You are giving time and again. Where it is mentioned the fact that they have confessed.
Again, Your Honor, as I said, they intentionally told everything to the coastal guard, which also include the happening of the shipwreck, which include the cutting of jugular vein as well, which falls under confession, Your Honor.
Counsel, for the sake of argument, if we agree with you that yes, they truthfully declared in front of the coastal guards. But the basic principle of confession says that confession before police is not admissible before the court of law. So why would you rely on confession?
Again, Your Honor, Section 37 and 41 says that if it is made in the absence of these three things which I have clearly mentioned.
That is the letter, and that's a subsequent stage. But the basic principle says that no confession can be made before police officials.
Okay, Your Honor. As we know, as a student of law, we know that whenever there is a law, there is exception available, and this is exception.
When there is no.
There is exception.
And do you think exceptions will prevent?
Of course, when the law is giving exception.
Means you are trying to negate the basic principle, the foundation.
No, Your Honor. Section 37 and 41 of QSO is also supporting our agree that.
So what is the basic principle of confession?
Confession is defined as a statement made by an accused, which must either admit in terms the offence or at any rate substantially at the fact which constitute the offence.
Which constitute
the offence, yes, Your Honor.
And it is a truthful declaration of whatever happened. Yes.
Indeed, yes, Your Honor.
It has to be judicial.
Judicial is not mentioned here, Your Honor.
Authorities are there, yes.
Indeed, Your Honor. Again,
in order to meet the ends of justice, the confession has to be very clear and transparent. Yes.
Indeed, Your Honor.
And where it can be made, police department is already on the side of prosecution. Do you think that they will be impartial?
Okay, Your Honor. Again, I am telling you, because Section 37 and 41 says if you remove the following three factors, it will become relevant, and after corroborating the confession with the facts and evidences, it will become relevant. Second thing, we can produce the coastal guard as a witness in the court as well.
Even then, circumstantial evidences are not enough. They are not conclusive.
But Your Honor, as per the confession, it is proved, Your Honor. Okay, now I would like to call my co-mooter to present her arguments on the remaining three questions. May I, Your Honor?
Yes.
Thank you.
Good afternoon, Your Honor. Your Honor, as our time has been ended, I request this honorable court to allow me to complete my arguments. Am I allowed? Thank you, Your Honor. I believe this is Myra Sobat's second mooter in the case of State versus Armagan Randhawa. I, Myra Sobat, on behalf of prosecution. I believe that my co-mooter, Mr. Hasnad Hamid, has proved his instances beyond any reasonable doubt and to the satisfaction of
Excuse me, counsel. Your co-mooter is totally failed to establish the case beyond any reasonable doubt. You may proceed.
Thank you, Your Honor. Your Honor, the third issue in the instant case is whether only Armagan Randhawa is liable for killing Dilrozain Khazalbash or not. Your Honor, not only Armagan Randhawa but Feroza Bill and other crew members are also liable for the murder of Khazalbash. Furthermore, Armagan Randhawa is considered as the principal accused in the instant case of murder, and the rest of the crew members are the co-accused in the instant case who abated the offence of murder. Abatement is defined under Section 107 of Juris Penal Code. It can be committed by way of instigation. It can be committed by... Yes, Your Honor.
What do you mean by instigation? How to instigate the other person?
Your Honor, instigate means that instigating any person to do that thing. And in the instant case, Feroza Bill signaled. It means Feroza Bill indicated Armagan Randhawa to kill Dilrozain Khazalbash.
That one expert can instigate another expert?
Yes, Your Honor.
How?
Your Honor, one expert can, because they were having the guilty intention. They were again and again approaching Dilrozen Kazalbash in order to kill Dilrozen Kazalbash, and therefore they are liable in the instant case for the murder of Dilrozen Kazalbash along with Armagan Randhawa.
Approaching someone does not mean instigating, it means insistence and suggesting. And suggesting is not an offense.
Instigating means to instigate someone to do anything. So here Feroza Bill is signaling, instigating or indicating Mr. Armagan Randhawa to kill Dilrozen Kazalbash, and the same is to be noted by this honorable court, Your Honor.
Indication has also fallen in the ambit of offense.
Yes, Your Honor. Yes, Your Honor. It comes in the instigation, and instigation is the one of the ways. And in
Can you hold accountable someone on the basis of just guilty state of mind?
yes, Your Honor, on the basis of guilty state of mind, and along with the actus reus, and along with the preparation and accomplishment which are available and present in the instant case, we can hold a person liable for the murder committed. Furthermore, in order to better assist this honorable court, I want to rely upon a judgment, that is JLD 1961 Lahore 212.
काउंसिल यहाँ पर आपने फिरोज़ा बिल को किसी केस में इन्वॉल्व कर दिया, लेकिन यहाँ पर उसका जो इंटेंशन था वो चेंज हो गया था। When it comes to para number 9, so however Firoza Bill rejected this option. It's not very clear regarding Firoza Bill. However, Firoza Bill rejected this option and proposed idea for the sake of survival that they should only cut one part of the body to get meat and eating senses with already gone. यहाँ पर उसके इंटेंशंस को चेंज हो गए थे. How can you claim that he is she or she is contributory liable in this case?
I would love to assist this honorable court on the instant issue. At the later circumstances in the facts of the case, it is mentioned that the Feroza Bill, when there was no hope of rescue, then Feroza Bill signaled Armagan Randhawa to kill Dilrozen Kazalbash.
Firoza Bill has not signaled Armagan Randhawa. Armagan Randhawa is
Both, the word both is mentioned, Your Honor. So it means Feroza Bill and Armagan Randhawa. Therefore, we are calling Armagan Randhawa as the principal accused, who also signaled but committed the murder of Dilrozen Kazalbash. But Feroza Bill, as being the abater, is equally liable for the punishment of the murder, though Feroza Bill has not been charged with section 302. Therefore, I want to assist this honorable court with the.
We don't have any specific provision for cannibalism. How you expect this court to bring this your case in under section 300 or 302?
Your Honor, cannibalism is also kind of a murder, because at the time when Armagan Randhawa cut the jugular vein of the Dilrozen Kazalbash, at that moment it amounts to the murder.
That we have a cannibalism case in Lahore, Bakar, but we couldn't give them capital punishment. At least they can get 1 year or 7 years. Then how you bring 3 or 2 in front of this court under these circumstances?
Your Honor, as I already mentioned, that cannibalism is a kind of a murder. When the culpable homicide amounts to the murder, then cannibal must also be charged under section with murder and should be punished under section 302 of Juristan Penal Code.
How do you define cannibalism?
Your Honor, cannibalism is an act of consuming an other human body's flesh. But in the instant case, in order to eat the human flesh of Dilrozen Kazalbash, firstly Armagan Randhawa killed him. That amounts.
Any relevant provision of law that would penalize the cannibalism? Any relevant law?
Indeed, Your Honor, I would refer to this court, the Queen versus Dudley and Stephen case.
You have appeared before Juristan Court of Law. Any court of law in the state case?
Sorry, Your Honor, I couldn't beg you.
You refer to international law, yes, an international judgment.
Exactly.
Another country.
Exactly, Your
Let's
Honor.
say that's a colonial precedent. But do you have any relevant provision under the Code of Jurisdiction?
As Your Honor, this has been committed in the first time in the history of Juristan. Therefore, we need to and we are bound to rely upon the international judgments. May I read the statement of the judgment?
For
Yes.
a murder case, we should be very specific about the time, about the place, and the weapon used, and the persons who are present at that time. Your all cases on presumptions.
Your Honor, I have supporting judgments in this regard. These are not my words. I am preferring to this judges that has already decided the cases. These are not my words. I am referring the judicial decisions to this honorable court.
Why do you think that international judgments are binding on us?
Your Honor, when there isn't any relevant law, there isn't any supporting authorities available in the Juristan, then in order to give the justice to the victim, we become duty bound to follow the international judgments.
Ms. Counsel,
Yes,
in
Your
particular case, in the case of murder, when a person is a principal accused, all the other parties must be doing any distinct specific role according to the principal accused. So what do you think that in this case, the other parties nominated, what were their distinct roles and why are intention? So what basic distinct roles they were playing in respect of this common intention?
Your Honor, I'm coming to this. The Armagan Randhawa killed Dilrozin Kazalbash by cutting his jugular vein, and Feruzabil aided and instigated Armagan Randhawa. Whereas Aruzagil, who is the third member of this occurrence, Aruzagil aided Mr. Armagan Randhawa by the presence and by eating the flesh of the Dilrozin Kazalbash. Therefore, they are liable for the punishment under 302 of Juristan Penal Code.
Okay, last question. You make the last wish.
Yes, Your Honor.
काउंसिल आपकी स्टेट का क्या नुकसान हो रहा है? Both neither the accused nor victim, right, is the citizen or the national of Juristan. दोनों नैना की citizen हैं. एक ने अपने बंदे का whatever जख्मी किया है, कत्ल किया है. And cannibalism is somehow lawful in their religion. What's wrong in it? आपका क्या नुकसान है?
Your Honor, murder is an international wrong, and the same has been committed within the territory of Juristan.
It is international matter, I mean, private community, whatever.
But it
is decided by the concerned court. I mean, to say the court
But
of 9.
Your Honor, I would love to assist you on this instant contention. They were in the service of Juristan. They were in the territory 240 nautical miles of Sawadar.
214. What is the territorial limit of state of Juristan?
It is 200, but it can be extended to 360 nautical miles.
Let me correct you. You cannot enforce your criminal laws except some laws that are related to, I mean, to say that immigration or income tax or pollution.
But Your Honor, according to United Nations Convention on Law of Seas, it is clearly mentioned that the economic zone of state of Juristan is 200 nautical miles, which
What does this mean? Exclusive economic zone
means it can be solely used by the state of Juristan.
for economical purpose,
The,
not for all domestic laws.
the can be considered as the territory of Juristan, Your Honor.
We don't think so.
Your Honor, if there is any other question, I would love to assist you. But if there isn't any question, I would love to proceed towards my other argumentation. Your Honor,
Time is up.
I request this honorable court to kindly allow me to proceed with my
Only
arguments.
2 minutes.
Okay, Your Honor. So I would like to assist this honorable court regarding the intention of Aruzagil. As the facts are ambiguous regarding the intention of Aruzagil, but I want to quote here certain judgments. That is JLJ 1996 SC 746 regarding the Your Honor, on the first page you can see that includes the offences of section 302 and section 34 of Juristan Penal Code, and it states that common intention is a state of mind which is not susceptible of direct proof and can only be inferred from the attendant circumstances of the crime.
And ये repeat करने effects को केस का कोड आप repeat कर लें,
So may I read
repeat कर लें
this instant case law?
जी, जहाँ से आपने start किया वहीं से कर लें।
It states it includes the section 302 and 34 of Juristan Penal Code, and it states that common intention is a state of
Change of intention, not common intention.
the intention can be termed as common intention, Your Honor, in the instant case, as it is the
Okay, proceed.
section 34 is relevant about the common intention which is mentioned, Your Honor. So it states that common intention is a state of mind which is not susceptible of direct proof and can only be inferred from the attendant circumstances of the crime. Common intention can usually be inferred from motive, preconcept, and pre-arrangement, which cannot always be proved by direct evidence. Hence, common intention has to be gathered from the facts and circumstances disclosed in the evidence. So, Your Honor, in the para 7, line 4, it is clearly mentioned when the occurrence took place, the crew discussed cannibalization openly. This word openly signifies the intention of Aruzagil. That at the time of the discussion, Aruzagil was present and the same was not objected. And here is another fact, that is presence of Aruzagil in the limited in this space, so it is impossible for a prudent mind to believe that the occurrence could hide from the knowledge and belief of Aruzagil. So held that the common intention of Aruzagil is relevant under Article 24 of Kanun-e-Shahadat Juristan Order. So there is another judgment regarding. May I?
Question. As we know that Aruzagil once rejected the cannibalism, and secondly, he suggests that we will use the parts of the body. Isn't it show that he is not willing to kill that person?
Your Honor, there are other facts that show that when there was no hope of rescue, Ferozabil agreed upon the idea of Dilruzain Armagan Randhawa in order to kill Dilruzain Kazalbash before his natural death.
Counsel, my fellow judge earlier asked that you're insisting so much for this case that it should be heard and adjudged by this court. But I see no adverse impact on Juristan. What do you think, how it has impacted Juristan?
Your Honor,
Because the adverse consequences were faced by Nana and Dilara.
Your Honor, it is the exclusive jurisdiction of state of Juristan, as it includes the nationals of state of Juristan as well.
It is within the local ambit of Juristan, but how has it impacted Juristan?
It has impacted because it includes the offense of murder, and the same was committed by the person who was under the contract.
It includes the offense of murder, but it can be tried by Nana and Dilaram too. Because
Your Honor,
whenever it was committed, it was the ship of Dilaram, and whosoever members were involved were of Nana.
I would
What about Juristan?
I would love to assess this honorable court on the instant contention. That is, if the state of Juristan is not providing justice to the victim, then the other person who are going to commit in this come in the service of Juristan in the future, they will be threatened that any such occurrence could be happen to them as well. So in
Also, if we refer this case to United Nations, as we refer the Kulbhushan case as we referred to the United Nations, because there are 2 or 3 countries were involved, what the prosecution will suggest?
Your Honor, as it is the matter that can be prosecuted and decided by the court of Juristan, so I don't think so that this can be referred to the United Nations. If there is a solution and if there is a platform to decide this instant issue, then there is no point of referring this case to the United Nations. If I have satisfied this honorable court regarding the instant case, so I would love to pray. In the lights of the arguments advanced before this honorable court and the arguments and the authorities presented to this court, I humbly and most respectfully pray to this honorable court that charge Armagan Randhawa and other crew members under section 302 of Juristan Penal Code and punish them with the hefty punishment in the interest of justice, equity and fair play. Thank you, Your Honor.
The defense counsel, you may proceed.
Good evening, Your Honors. I'm here on the behalf of defense, Mr. Armagan Randhawa. I am Ms. Shagufta Ramzan. I will be assisting the court with the first 4 issues, and my co-counsel will be assisting the court with the last issue. May it please the court. Our first issue is whether the court of Juristan has jurisdiction to try the case or not. The court of Juristan has no jurisdiction to try the case of killing.
Counsel, please speak louder.
I'm sorry, sir. The court of Juristan has no jurisdiction to try the case of killing of Dilrozet Khazalbash on the following grounds: that Armagan Randhawa and Dilrozet Khazalbash were not the nationals of Juristan. Number 2, they were not in the contract of Juristan. Number 3, that the ship in which the incident took place was not registered in Juristan. And number 4, the killing of Dilrozet Khazalbash took place on high seas, which is beyond the territorial jurisdiction of Juristan. Economic exclusive zone is dealt under the United Nations Law of Seas, and UN clause does not provide any provisions regarding criminal jurisdictions in the high seas, and also no Juristani law deals with the criminal jurisdiction in economic. Yes, sir.
Do you know about the concept of floating island? Would you like to interpret it?
Sir, there are some islands that are near some states, and the matters of that island will be dealt with in the state that is near them.
It deemed to be the territory of that particular state, no?
Yes, sir.
So, the offense was committed on a ship. The ship comes in that concept as well.
No.
So, don't you think it is implied in the territory of state of Juristan?
It does not, because it was in exclusive economic zone. Economic.
Speak loudly, please. Speak loudly.
I'm sorry, sir. The exclusive economic zone is dealt under UN clause. The high seas is
Exclusive economic zone, territory of Juristan.
The territory.
If any offense is committed on any ship or aircraft, right? And that ship or aircraft is having the flag of any state, like, it deemed to be the territory of that state.
Then,
so don't you think that the ship was hired by state of Juristan, hence it deemed to be the territory of state of Juristan?
but the ship did not have the flag of Juristan. It was registered in Babul,
It was hired by the state of Juristan.
but did not have the flag of Juristan.
So it means they enter in a contract with Zisu company for that specific way.
But they only hire their services for research purpose of feasibility of ocean. They did not have the flag of Juristan, and the services were terminated. So, and beside that, Juristan has no. Yes, ma'am.
The services are being terminated. How it is proved? Because they are on contract, then they go to the sea and their trip was started.
It is mentioned in the facts that their contract will be automatically terminated after 1 year. They came into the contract on 1st June 2022, and that contract was terminated on 1st June 2023. The incident took place after that.
Do you know the term force major?
I'm sorry, ma'am?
Under Contract Act. Do you know the term force major?
I'm.
If you are not, I will explain it to you. The force major is there when there is a contract between two parties, two entities, and there is a disaster, unavoidable disaster. It means until, as we saw in the COVID-19, there is in their contract, the businesses are very much affected. But the contracts are still going on if the date has been expired. So it is called force major. It means the contract is still going on until and unless they came back and submit their report.
The case of the nature of the case is criminal, and Juristan has no criminal jurisdiction after 12 nautical miles. Thus, we cannot force apply it here because we do not have any criminal jurisdictions after 12 nautical miles.
According to the term force major or concept of force major, they are under the natural disaster. So the project is going on.
But we also have a point that it
It means they are in the service of Juristan and under section 4 of CRPC. They are triable by us by this court.
But we also want to mention that if we trial the case on behalf of NENA, our diplomatic relations and bilateral ties.
Speak louder, please.
I'm sorry, we're talking, sir. If we trial the case on behalf of NENA, our bilateral ties and diplomatic relations will worsen. That's why we do not want to try this case in Juristan. We want a third place to try this case. So I want to give an example of Enrica Lexis case. It was decided in permanent court of arbitration, and beside that, Juristan and NENA both are signatory states of Rome Statute of International Criminal Court (ICC). So we want this specific case to be not have any kind of jurisdictions to try this case.
Yes.
Yes, sir. Yes, Your Honor.
Counsel, you mentioned that Union clause is silent regarding criminal jurisdiction.
But it deals with high seas. It happened in high seas, and they will come up with some, they have some provisions. They will find some provision, but our criminal jurisdiction is only till 12 nautical miles. We cannot go beyond that. Besides that, our prosecution stated that the act was committed within the territory, but they are mistaken because the sovereignty extends up to 12 nautical miles, and it was committed in exclusive economic zone.
Would you assist the court regarding Article 73 of your clause?
Article 73 of UN clause, unfortunately I cannot, because it has no provisions regarding the criminal jurisdictions, and I cannot afford.
Sure.
Yes, sir. There is no criminal jurisdictions.
And what about Article 3? I am assisting you, but still not saying.
Can you please assist me a little more?
I have assisted twice and again, but resisted.
Can you please say again?
Counsel,
Yes, ma'am.
according to them, after completion of task, they towards to Zawadar coastal, and also coastal Zawadar registered this case in 2023 or 25th May 2003. On 1st June 2022, Zawadar became the state of Juristan. Its immediate jurisdiction of this case applicable jurisdiction.
Ma'am, yet again, Zawadar is in Juristan. The incident that took place was near 340 nautical miles. It was an exclusive economic zone. It is dealt.
Ms. Counsel,
Yes, sir.
in such cases of inconvenience,
I'm sorry, sir.
at times we refer to a word that is known as balance of inconvenience. That is that, for the sake of argument, the two nationals were of Naina. But the more inconvenience lies towards the state of Juristan. So that means that the ship was in their territory, 340 nautical miles, including the continental shelf, obviously. And obviously section 4 of JPC is applicable here because they were not the citizens, however they were in the services of Juristan. So what is your stance on this particular motion?
Two things. First, no criminal jurisdictions after 360. It was 12 nautical miles. Second, again, our bilateral ties and democratic relations will worsen if we try this case in behalf of NENA. I would like to proceed to my second issue. Thank you. Our second issue is whether the killing of Dilruzain Qazalbash was murder, considering the circumstances of this case or not. Considering the circumstances of the case, the killing of Dilruzain does not amount to murder. The reasons are Number one, that there was doctrine of necessity, means to take certain actions that must be taken at a particular moment wherein such acts would not otherwise be regarded with the scope of the law in general legal situation. So in
Learned counsel.
yes, sir.
Is there any limit of theory of necessity?
Among the 6 elements of the necessity of defenses, our third element justifies this. It is the causal nexus prong, and it says the action taken in the cases consider all appear to meet this prong in that the action of killing will usually have the direct result of saving a greater number of lives, for example, by cannibalizing the flesh of the victim. Besides that, there was no mens rea, and furthermore, it is to be noted that the crew members were in a state of extreme duress. They had been adrift for days without food and water, and they were desperate to find a way to survive. On June 11th, a suggestion was made to draw lots. All of the crew members, including Qazalbash, agreed and participated in the drawing of lots. The lots were drawn, and Dilruzin Qazalbash was selected. All of these are stated in para number 8 of the facts. And beside that, we want to give the sortation. Sortation, or the drawing of lots, is a centuries-old custom of the sea. Seamen have participated in it for centuries in situation of grave travail, when they must take difficult decision about who will be sacrificed in order to save the lives of others. We have 2 examples related to sortation. We have Chapman Law Review and Speluncean Explorers. This custom suggests that when a decision has to be made by a loss, the victim must yield to their fate. If they resist, force may be used to coerce commission. We have, yes.
You mentioned that there is no guilty intention. There are certain offences where even there is no guilty intention, where concurrence to take place, but still the person or he or she is subject to or liable to any substantive law. लेकिन यहाँ पर ये conduct crime तो है, no there is no guilty intention, लेकिन conduct crime तो हुआ. There are certain offences, again I would quote strict liability offense, vicarious liability, conduct crime. लेकिन क्या इसका ये मतलब है कि अगर guilty आपका वो ना हो, intention ना हो, लेकिन आप किसी को नुकसान पहुंचाओ, और आप ये प्ले ले लो कि हम exempted हैं क्योंकि मेरा guilty intention हो.
Sir, one element of the crime is missing, mens rea. Beside that, we are defending Katle Hamd. They did not commit Katle Hamd. Yes, ma'am.
Aren't you opening the door for everyone who have been caught by any disaster to be free to eat any of his fellow beings?
But we must also keep in mind that they had had to do it because if we
in droughts, which we face most of our areas, especially in Tar and in Balochistan area, then we allow people to eat their fellow beings. Are you allowing them? Are you suggesting give up, open a gateway to them?
we want the third place to held it in a way that will not open any doors to anyone. We would want to present that if we put 2 things like 4 lives or 1 lives, which would be heavier? 4 lives, of course, we cannot lose them. So in order to survive, they had to cannibalize on the flesh of Dilruzin Qazalbash to survive.
For your reminder, in previous year, extremely drought areas, and people are dying in front of each other. If we follow your rule of life, then we allow the people to eat their fellow beings, their relatives, their children, if they die.
We first are saying that we should not try this case. Secondly, we are defending Katle Hamd. It is punishable, but not with willful murder, not with Katle Hamd. Proceed.
It means the family of the victim should not raise objection on this because as per your presumption, Dilruzin Qazalbash gave his consent.
Yes, ma'am.
Also, you mentioned that sortition. Yes?
Yes, ma'am.
Sortition is a centuries-ago custom. It clearly imparts the meaning that it was in a primitive society, but today it's a modern nation state. And in modern nation state, the law is always visible.
But they were
customs. Those customs which try to try to degrade the morality or the legality of a state?
First of all, they were stranded of any laws. They have to come up with something, and the only thing that was available to them was the customs of sea and custom sustains. They have to yield of their fate.
There were other alternative options too.
Can you give me an illustration?
Yes, they fought a turtle.
But after that,
They have something.
after that they couldn't. That's why they had to come up with the situation of sortation, cannibalization. If they could, why would they do it?
Okay, Council, you place documents in front of us.
Yes.
I think they are not supporting.
No.
Because they are about self-defense. And self-defense is something very much different from the cannibalism and circumstances of your case.
Is it Chapman Law Review or Speluncean Explorers?
It is Harvard Law Review.
Wait a minute, ma'am.
About the self-defense. And self-defense is very different circumstances of your case.
No, Harvard Law Review has an example of Speluncean explorers. In that case, Roger Whitmore was drawn for cannibalization.
Come on, page 175. You are asking us about the agreement of your accused on the basis of mens rea. And they are saying that defendant mens rea required the murder to take the life of other living being.
Ma'am, but there's an also example on stating 174 that it states that Justin Baldwin states that it's a persuasive principle. He also said that it is worth remembering that in any situation in which the necessity doctrine applies, someone's rights are going to be violated. And here they had to do something. And Diruddin Qazalbash's rights happened to be violated because he was in a really severe situation, and the other three had to survive. So even though he was not in a feeble situation, and they were
Self-safety. I can survival of my other fellow beings to kill a living being. How can you justify this?
Mr. Diruddin Qazalbash was already in a coma. If they did not feast on his flesh, he would have died, and that meat would not have been of any use. And in result of that, the other three crew members would have died as well. So they had to do something about it.
The last question.
Yes.
Now, that is that these were the expert people. Kept strict treats. Just tell me this, that were they not able to differentiate between a meat of a man as well as fish? Why was that third person, a female, was referring it to very delicious meat? Who caught this fish? So can you not differentiate between the fish as well as a human meat? What is the difference? And why were they unable to differentiate?
First of all, maybe because of extreme starvation. No insane person would be able to think sanely. First, and besides that, I want to refer to Your Honor that we are not talking about self-defense here. Our submission is necessity of defense. Is that clear? Should I move forward? Thank you. Our third issue is that whether only Armagan Randhawa is liable for the killing of Diruddin Qazalbash or not. No, Armagan Randhawa is not solely liable for the killing of Diruddin Qazalbash. If any criminal liability were to be assigned, then it should be distributed among all those involved. But in this case, the principle of common intention does not apply, as the actions were driven by the necessity to survive rather than a shared criminal plan. Whatever Armagan Randhawa or the other crew members had done was in good faith. It was done in order to save lives and avert a greater harm. There was no predetermination and there was no shared intent. Our fourth issue is that whether cannibalism is lawful under the theory of necessity or not. The legality of cannibalism falls under the theory of necessity. Again, our theory of necessity varies upon the matter of jurisdiction and specific circumstances. I would again like to quote Justice Baldwin in Chapman Law Review 174. As I said before, it is worth remembering that in any situation in which the necessity doctrine applies, someone's rights are going to be violated. Someone's rights are going to be violated. If I am of no further assistance, I would like to call my co-counsel. May it please the court. Thank you.
Good evening, Your Honors. I am Fahim and I am appearing on behalf of the defense. I will deal with the last issue of the moot problem, that is whether or not the principle of common intention applies to Eruzagil and others. Your Honors, I want to state it that it is clean and clear that there is no application of Section 34 in this case. Basically, the act of murder is defined as the unlawful killing of a human being with malice aforethought or with evil intent. As a matter of fact, in this case, whatever the crew members did was undeniably a collective response to an extreme situation, and there is no evidence to suggest that Eruzagil and others had a pre of Dilrozen Qazalbash. Whatever we want to submit again here that whatever they did was a response to an extreme circumstance, and the applicability of Section 34 doesn't apply here, on Your Honors.
Common intention, you said. Common intention definition, Article 23 Kanun Shahadat, when two or more persons act conspire together to same offense. So in this case, even maybe four persons included with some same offense. But you say that not common intention in this case applies.
But about the open discussion about each other, whether to kill him or not, and we will kill him after 1 day, we will kill him after 2 days. Isn't it a discussion at common intention?
Your Honors.
Yes, and Mr. Counsel, with the continuation of that question, यहाँ पर एक specific role भी play किया जा रहा है. That lady was holding the foot of the murderer. तो यहाँ पर इन तमाम relevant facts को note करते हुए common intention तो हो रही है. So what do you say about that?
Definitely, Your Honors. What your respected Your Honor you were talking about was the persuasion, because they had decided who have to die in the sortation that we have submitted before, that who have to die, and they.
All of them are adults, all of them are educated, all of them are known to the international and local laws. Aren't they selfish to just survive their life, safeguard their lives, they kill a person? This isn't a common intention.
Your Honors, we have already made the submission that they did not perform the attack because before they drew lots, and it was decided who has to die. After that, they persuaded that act. And what we are trying to submit here, that there was no malice aforethought, there was no criminal intent. It was a response to an extreme situation. Here we are defending that there was no criminal intent or mens rea, Your Honors. May I proceed to the prayers? Respected judges, in the light of above arguments and the submissions made by my co-counselor, in the light of provisions of the laws of Juristan and the principle of justice, equity and fair play, the defense most humbly prays that the court may dismiss all the charges, dismiss the charges of Qatl-e-Amd, then dismiss the charges of common intention against Armagan Randawa and the other crew members. May it please the court, this is all we have submitted. Thank you.
Prosecution, you may proceed for rebuttal.
They have only 2 minutes.
And you have only 2 minutes.
Your Honor, may I proceed toward the rebuttal? Your Honor, defense mentioned that the offense was committed in the high sea, as the offense was committed within the 240 nautical miles that comes in the jurisdiction of Juristan. High sea is not mentioned in the facts of the instant case. Furthermore, defense again and again admitted that the occurrence occurred in the exclusive economic zone of Juristan. It means they are not supporting their own arguments. They are in support of the jurisdiction of Juristan. Furthermore, defense argumented that state of Naina can try the case but failed to justify same with any relevant provision of jurisdiction of Naina which could justify the jurisdiction of Naina. Furthermore, defense mentioned participation of Qazalbash in drawing lots, but not mentioned that after the nomination, Qazalbash denied because he loved his life. Defense produced authority about self-defense and argumented in support of necessity. It means citation in support of necessity and argument in support of self-defense and arguments in support of necessity. Again, defense contradicted in their arguments. Furthermore, Dilrozain Qazalbash was in coma. Defense mentioned and argued Dilrozain Qazalbash was in coma, therefore killing him is justified. But before his natural death, killing any person, before his natural death comes into the murder, and the penal code. Furthermore, Your Honor, defense denied intention of Aruza Gill, but as per the submissions and as per the submission to be made before this honorable court, that the discussion of cannibalization was made in the presence of Aruza Gill, and the same was not denied by Aruza Gill, and presence of Aruza Gill in the ship and eating of the flesh of Qazalbash is relevant against the intention of Aruza Gill. Therefore, I respectfully pray to this honorable court to punish the Armagan Randhawa and other crew members with the hefty punishment and under section 302 of Juristan Penal Code and 34 in the interest of justice, equity and fair play.
I wish your wish comes true. Thank you very much.
Thank you, Your Honor.
The defense counsel, you may proceed for sole rebuttal, and you have only 2 minutes.
May it please the court. As our prosecution counsel said that there's nothing stated about high seas in facts, but there is stated exclusive economic zone and it comes in high seas. Beside that, we are not arguing that there's no jurisdiction, we are arguing that there's no criminal jurisdiction. And about without the denial of the consent of Dilrozain Qazalbash, I want to again quote the exhortation that custom suggests that when a decision has been made by a lord, the victim must yield to their fate. If they resist, force may be used to coerce submission. And about the common intention, she was aware of it. About the discussion sortation, but later it was done without the awareness of Aruza Gill. May it please the court.
The court is adjourned for 2 minutes. All rise.
Before we leave the court, this formality has been finished. But I really appreciate all the participants, especially Shagufta, Myra and Sanita, your hard work and your presentation and your spoken well, because it is very, as yesterday I said, it is really an eye-opening for us. Being the practitioner of the Supreme Court and the High Court, I really appreciate and I really clap for.